also like to take this opportunity to welcome management and staff, as well as members of the public that are following us through the various live streaming channels. We've just then moved to the adoption of the agenda. It's got a long agenda today, and I would like to say that the indications is that item 5, which is the guidelines on volume risk sharing mechanism between petroleum pipeline storage and loading operators and third parties, be moved to be the last agenda item in the open meeting. With that, members, if you can show by raising your hands that you support the agenda as put forth with that change. Thank you, Madam Maseti, Mr. Kumede, Madam Simane. I also support. You just help me, or also Mr. Sbanda and Advocate Tole. Thank you very much. Madam Masangani, if you can just help me from time to time to welcome, to note when members raise their hands. Sometimes it's difficult to see from this side. I would then like us, without any further ado, to move to item 4, which is a declaration of interest. May I please request all of you members to please send your filled declaration of interest forms to the Secretariat, Madam Masangai, by way of sharing the annotations with her. Madam Masangai?
Chair, before you move to the open meeting, please note that Mr. Sibanda is in the meeting for 2 hours until 2:30. Thank you.
Okay, thank you. We're already in the open meeting. We'll then continue with that. The declaration of interest, any interest to declare verbally in this meeting, members, management, or staff? By show of hands, please. I see that there is none. So without any much ado, let me then proceed to agenda item 6, which is a report on the transitioning of the efficiency adjustment factor and volume rules element of the tariff methodology for petroleum storage and loading facilities, version 5. Over to you, Madam Toa and the team. I will only give you a maximum of 2 minutes for all these items, save for the last item that we'll be dealing with.
Thanks, Chair. I won't take any more time then. I'll allow Ms. Yogwana to introduce the item, which is the annual report on the transition of the efficient adjustment factor and volume rules. Ms. Yogwana, please briefly introduce the item.
Thank you, ma'am, and thank you, Chair. Morning, members and colleagues. The purpose of the submission is to request the PPS to note and recommend for noting by the ER the annual report on the transitioning of the efficiency adjustment factor and volume rules elements of the tariff methodology for storage and loading facilities, version 5. The transition process was first approved by the ER of March 2022 for the period of 12 months in order to prepare the industry for the implementation of version 5 of the methodology. The report thereof was tabled at the PPS of 8 February 2023 for noting, where the PPS members requested that the transitioning period be extended. However, the extension would only be limited to the 2 elements, efficiency adjustment factor and volume rules, considering that the challenges observed were limited to these elements. So in terms of the update on the report served at the meeting of Feb 2023, NESA had set volume targets for licenses that are listed on paragraph 5.3, and the results are outlined in paragraphs 5.4, 5.5, and 5.6 of the cover submission. And for this current transition, paragraph 5.7 lists 9 tariff applications that were considered by the PPS in the 2023-24 financial year period, which were used for the current transitioning of the efficiency adjustment factor and volume rules. The results of the transitioning are summarized in paragraphs 5.9 and 5.10 of the cover submission. And they show that out of the applications processed so far in that period, 3 were identified as inefficient when compared to their peers, and therefore had volume targets set, which are to be achieved within a period of 12 months. And NESA will continue to monitor volumes in order to determine the performance of these identified facilities. The report is attached with the detailed results and the implementation of the transitioning. It is therefore recommended that the PPS notes and recommends for noting by the ER the annual report on the transitioning of the efficiency adjustment factor and volume rules elements of the tariff methodology for petroleum storage and loading facilities version 5. Thank you, Chair.
Thank you. Members, any questions, comments, guidance to be provided? By show of hands, please. I don't see any from my end. I now see Mr. Sibanda. Thank you, Mr. Sibanda, for the platform.
Thank you, Chairperson, and thank you to the team. Chair, the question that I have really is whether the setting of volume targets is achieving the intended outcomes, because if you look at table 1, the difference between the volume, the target set, and what's been achieved is just astonishing. In fact, the volumes seem to have declined from the previous achieved volumes. So I'm just wondering whether it's the volume targets are actually having the intended effect or outcome. And it might be useful to perhaps get an understanding from the licensees on what are the challenges, because I mean, if you look at what we said and what was achieved, it's just, like I said, just astonishing. And I'm not sure whether this is really helping us, but I think for all intents and purposes, it might be necessary to talk to the licensees to try and understand what's happening here. Especially if the volumes are actually declining or decreasing instead of increasing. That's the only comment that I have, Chair. Thanks.
Thank you very much, Mr. Sibanda. I'm not seeing any other or Madam Massetti.
Chairperson, just to emphasize on the point raised by Mr. Sibanda, from my side, I thought he was going to cover it. From my side, that issue is concerning the fact that the output is constant or declining, yet the prices are going up. It is really showing that the energy regulator is actually not able to reverse a situation like that, or to avoid a situation like that, because we are supposed to curtail any market power or any monopoly. But now, if you see that the output is declining, yet the prices are rising, it's actually a situation that shows that the monopoly exists and we're not able to deal with it. Yet our role as an economic regulator is to curtail that kind of a situation. So what we see here is that kind of a situation. And it's not a good outlook at all from an economic perspective or economic regulation perspective. Thank you, Chair.
Thank you. Any other hand? Okay. May you please respond?
Thank you, Chairperson. I'll start with the responses. If there's any need for Ms. Yogan to add, she'll also comment. But just to highlight that, I think that the challenge here is that predominantly the utilization of these facilities that we license is driven by demand. And what we have noted, even also from the petroleum pipeline system side of things, is that the demand, like in terms of product, has not fully recovered after COVID. So the small wins that we have identified to date with these volume rules and efficiency adjustment factors is one, the fact that licensees that are considered inefficient will not be claiming clawback, especially for volume-related clawback, where they have not achieved their projected volumes. And then secondly, we are conscientizing licensees of their inefficiencies compared to their peers. So those are the small wins we have identified to date. And I think from our tactical planning session this year, we have come up with an initiative to engage licensees as we're receiving their applications, so that, like before we set the volume targets, so that the challenges that they encounter or any limitations in them attaining the volumes set may be catered for before the decision is taken. So we expect that to also enhance this. Otherwise, in terms of part of what we intended to do, which is conscientizing licenses of their inefficiencies, and also curbing this issue of having licenses claiming volume clawback whilst they are considered inefficient. So that part, those two elements, I think, are the small wins that we can talk to so long. Otherwise, we're committed to continuous improvement on this matter. So Ms. Maseti's comment as well, that the input being elements of the allowable revenue is increasing, whilst the output is either constant or decreasing. It's also an issue we are trying to resolve from our end. So with these biannual reports, we'll also be touching on that. Thank you. Chair.
Mr. Sibanda, I see your hand is up for the platform, sir.
Yes, Chair. Thank you to Ms. Boko. Chair, I think perhaps let's be careful not to generalize the cause for the declining volumes, because remember that we set these targets based on the capacity turns of peers. Now, if that is the case, does it mean that the whole industry then is experiencing a downturn or declines? But for me, I think perhaps I would have loved, if that is the case, I would have loved to see evidence of that. Otherwise, I do take the point around the clawback and all of that, which is a good thing. But I think perhaps to generalize, or well, at least it must be backed up by something that says, yes, this is what the trend in the industry is. Then I will understand. Thank you, Chair. Chair, you might be on mute.
Apologies there. I think I pressed the wrong button here. what I need, Madam Yogan, if you can just respond quickly and to the point, so we can move towards a decision.
Thanks, Chair. I think the point where Mr. Sibanda speaks to what we've also concluded on in terms of that we may have to change the categories for identifying peers, because in addition to the challenges in the total demand in the country, the peers might have additional factors that affect their volumes. For instance, the location may enable the efficient peers to perform better than the inefficient peers in inland locations, for example, or in rural areas. But with that regard, we noted that the intended outcome or effect of the efficiency will be long term, and as such, we are going to continue to add a volumes project that's going to focus specifically on these factors, and also try to change the categories so that we don't mistakenly group some licenses as inefficient when in fact it's the market conditions that do not allow for improvement. Thank you, Chair.
Thank you. I see a thumbs up, and it is my understanding that this is not necessarily generally applicable or national applicable QTIP for a specific location, and that the rate of return methodology has got this inherent perverse incentive in terms of increasing the tariff when the volumes are decreasing or remaining the same when we've got a situation where the numerator being the RAB in the main remains the same. So the volume rules being set are actually seeking to remedy that. And I think that should be the approach that we are taking, and that we are at the beginning of this process, and therefore we need to carefully engage with stakeholders to understand the other factors that could be affecting their volume situation, and adjust as we move along, because we seek to improve from where we've been or even where we are right now. Members, I've seen the thumbs up, and then with that, I'd just like to go to the recommendation, which is for the PPS to note and recommend for noting by the energy regulator the annual report on the transitioning of the efficiency adjustment factor and volume rules elements of the tariff methodology for petroleum storage and loading facilities version 5. By show of hands, members, if you support the recommendation. Thank you, Mr. Sibanda, Madam Maseti, Mr. Kumete, Advocate Stole. I don't see Madam Simane. Madam Simane? I don't see Madam Simane. Maybe it's got technical glitches, but the majority have supported their recommendation. So your recommendation is supported, Madam Toy and the team. We then proceed to item 7, which is a decision and reasons for decision on the tariff application by VOPEC Terminal Durban P2I Ltd for its petroleum storage facilities located in Island View, Durban, in KwaZulu-Natal province. You've got 2 minutes to present. Thank you.
Thank you, Chair. I think Mr. Ndlovu, can you kindly come in?
Thank you, Chair. Good afternoon, members and colleagues. In accordance with the delegation matrix, the PPS has the authority to make recommendation to the ER as VOPEC's allowable revenue for the 2025 and 2026 financial year is greater than the amount stipulated in the delegation matrix. Chair, VOPEC applied for capacity-based tariffs of rands per cubic meter per month, which is in line with its commercial agreement and business model. VOPEC applied for tariffs of 267.59 rands per cubic meter for the 2024 financial year, 283.71 rands per cubic meter for the 2025, and 306.27 rands per cubic meter for the 2026 financial year. In assessing the application, we determined tariffs of 261.07 rands per cubic meter for the 2024 financial year, 278 rands per cubic meter for the 2025 financial year, and 300.06 rands per cubic meter for the 2026 financial year. The difference in the tariff calculated by VOPEC and NELSA is mainly due to the equity adjustment values for the work calculation provided on page 16 of the RFD, and the net working capital values provided on page 13 of the RFD. It is therefore recommended that the PPS recommends for approval to the energy regulator the decision and reasons for decision documents attached here to as an extra A. Thank you, Chair.
Thank you, Mr. Ndlovu. Any questions, comments, guidance members, by show of hands, please? Advocate Stole, platform is yours, ma'am.
Thank you, Chairperson, and thanks to the presenter. Chair, I just have one point, and I think it's a point of correction. Under page 5 of the submission cover, on 4.11, I think we're saying that the application was received within 2 months before the effective date of the tariff applied for instead of 6 months. But we then say that the application was then considered based on the fact that it is up to December 2025. I thought, Chair, it may be an error because if one looks at the title, it says the application is for 1 January 2024 to 31 December 2025. And as well as to find out that is that reason a valid reason that we considered that they submitted within 2 months before the implementation, and therefore then, because they have applied for multi-year tariff, and therefore then that's why we considered it. Otherwise, Chair, I may have a problem in that we may be having all these time frames that needs to be complied with, and if we allow licensees to submit late because they are applying for a multi-year tariff, it may just be a problem. Maybe the reason for us considering it when it was submitted 2 months before the implementation, should the tariff be applied, we need to give better reasons than what is given there. Thanks, Chairperson.
Thank you. Advocate Stole, Mr. Sibanda, over to you, sir. Mr. Sibanda, are you covered?
Sorry, Chairperson. My apologies. Chair, there's an argument, just one issue from my side. So there's an argument that's being made in the submission that the tariff should be capacity based. But when I look at how the tariff has been calculated, it's actually based on throughput volumes. And the question that I have is, it's not clear to me what explains the drop in forecast volumes on table 5 on page 10, because volumes have been increasing from 2022 to 2023, and then all of a sudden there's a huge drop in the forecast volumes going forward, and it's not explained. So the justification that's provided on page 9, it's more an argument that says we should be applying a capacity, or we should be using a capacity-based tariff. But then we then proceed to use throughput volumes, and we accept this drop without any explanation of what is causing that. So I was a bit unclear as to the link between the argument for capacity-based tariff and the volumes that are projected to be declining without any valid reasons, considering that they have been increasing over the past 2 years. Thanks, Chair.
Thank you, Mr. Sibanda. May you please respond? Central in the team.
Thank you, Chair. I'll start with Mr. Sibanda's question on volumes. So, Chair, here, VOPEC, as they say that they charge capacity, which is rands per cubic meter per month, they project that this capacity is more like turned, and as the AR is determined annually, they deem that this capacity which you released out in that particular month, and then there's 12 months in the year. So we turn this to calculate the annual volumes. They took out this capacity and multiplied by 12 times. But they charge more on the capacity utilized or leased out rather than the volumes pumped out. And Chair, there's even a benefit or gain if the licensee, the client, turn the capacity or the volumes more than once in that particular month, because they'll be paying for that specific capacity. And if there's additional volumes that are turned annually, that's a benefit to them, Chair. So the volumes are based on the capacity. It's just the month, to calculate it annually, the capacity is multiplied by 12 times. And then, Chair, going to the CEO's question, we will look into that. Chair, also maybe worth noting is that this licensee utilized services of a consultant. So we had pre-engagement with them prior to them formally submitting this tariff application. So there were maybe delays in them submitting 6 months prior, as they were still in signing up with their consultants, Chair. Thank you, Chair.
I think we need to enhance that paragraph to say what actually the reasons are, and noting that you could then consider it from the point that there are other subsequent year to also to also consider in the application. But having said that, Madam Bogo, I've seen that you wanted also to add.
Oh yes, sir.
And please ensure that you address the question raised by Mr. Sibanda regarding the justification for the decrease in volumes.
All right. Okay, let me start with the CEO's question. Like in terms of the reason for us accepting the application, though it was submitted just 2 months before. So we also considered the fact that if we were to reject the application, under normal circumstances, the licensee would then go back and then just remove the first of the 3 years. And then it would then meet the requirements. So what we are doing in this decision is that the tariff for the 2024 financial year is going to start from the day of the decision and not from the 1st of January. And then also to add on Mr. Sibanda's question regarding the volumes dropping. So in effect, if you look at table 5, what we do when the licenses are using capacity-based volumes, we also check the reasonability of those. So the volumes you are seeing for 2022, 2023 are the throughput volumes, or the actual throughput volumes. But then 2024, 25, 26, these are capacity based throughput. Like this is an assumption of throughput based on capacity being turned once a month. So you'll see in some of these VOPEC applications, the actual volumes would be lower, whilst the throughput or the capacity based or assumed throughput is actually higher. So we wanted to just check if this is reasonable. If it wasn't, maybe at the ranges of about 6 million, would then say to the licensee that this is the 10 of once a month is not actually reasonable. But then because the volumes are still arguably closer to once a month than twice a month, we accept it for this facility. But then for the other facilities, you will see that the capacity-based volumes are actually higher than the actual throughput volumes. Thanks, Chair. Hope that's clear.
Mrs. Banda? Thanks, Madam Mbogo. Mrs. Banda?
Yeah, Chair, I'm covered, Chairperson. Thank you. Maybe just one issue for enhancement on page 31, table 5. I think it would assist if colleagues could just indicate the percentage changes, because whilst we say that the expenditure increases are in line with CPI, if you look at corporate expenses, they're actually double CPI. So perhaps if you could include the percentage increases, that would help in terms of understanding what is going on with the individual line items for operating expenses. Thank you, Chair.
Thank you. I take that as an enhancement. You would just by thumbs up if you are fine with that incorporation, Madam Mbogo. Thank you. So just put that percentage for each line item so you can assist in indicating that. But I think also you need to look at the issues of volume much more closely, because for me, irrespective of what methodology or you use, whether it's capacity-based or throughput-based, the actual volumes shouldn't be changed just because of that. So going forward, look at that, monitor this closely, like you do in terms of the other licensees. I note that Madam Maseti's hand is up.
Thank you, Chairperson. Chairperson, I thought that I didn't want to. I thought that you would also consider input on the chat, where I requested that perhaps the team must also indicate the designed capacity so that we are able to see or to compare the operational capacity or what is being utilized from the designed capacity, and then do the comparison appropriately. Also, when we look into issues of efficiencies, but also with regards to the volumes that are going through the capacity that is invested. Thanks, Chairperson.
Thank you. Team, I take that as an enhancement that you have the design capacity and then operational capacity, and then be able to indicate. And I see that you show a thumbs up to say that going forward you'll have to indicate that, noting that operation capacity will remain redacted, but still for the purposes of the regulator seeing that there is efficiency, you do that. Okay. Having noted that, it then takes me to the recommendation, which is on page 12 of 40. It is recommended that the Petroleum Pipeline Subcommittee, PPS, recommends for approval by the energy regulator the tariffs of 267 Rand 59 cents per month per cubic meter, 283.71 Rand per cubic meter per month, and 306 Rand 27 cents per cubic meter per month for the 2024 financial year, 2025 financial year, and 2026 financial year, respectively, and recommends for approval by the energy regulator decision and reasons for doing document attached here to as Annexure A. By show of hands, members, if you support this recommendation, including the enhancements that need to be made. Thank you, Mr. Kumete. Madam Maseti, Madam Simane, Mr. Sibanda, Advocate Stoll. I also support. This then concludes item 7 and takes us directly to item 8, which is also a tariff application. A tariff application by Vopec Terminal Durban for its petrol loading facility in Island View, Durban, KwaZulu-Natal Province. Over to you, Madam Toa and the team.
Chair, thanks. Mr. Ndlovu is still on the floor.
Thank you, Chair. This is an application also by Vopec for its loading facilities in Island View. Chair, similarly to the previous item, they also deem a capacity-based tariffs of rands per cubic meter a month in line with the storage facility. However, Chair, here what's important to note is that there is no actual tariff charged for the loading arms, as they are considered more part of the storage business. So, Chair, Vopec applied for tariffs of 50.04 rands per month for the 2024 financial year, 52.77 rands per month for the 2025 financial year, and 55.22 rands per month for the 2026 financial year. In assessing the application, we determined tariffs of 49.34 rands per cubic meter per month, 52.19 rands per cubic meter per month, and 54.61 rands per cubic meter per month for the 2024 to 2026 financial year. It is recommended that the PPS approves the tariffs provided in Table 1 of the decision and reasons for decision document. Thank you, Chair.
Thank you, Mr. Ndlovu. Members, any questions, comments, or guidance? By show of hands. Seeing no hands, I would then like to move to the recommendation, which is on page 10 of 34. It is recommended that the Petroleum Pipeline Subcommittee approves the tariffs of 50 Rand 4 cents per cubic meter per month, 52 Rand 77 cents per cubic meter per month, and 55 Rand 22 cents per cubic meter per month for the 2024 financial year, 2025 financial year, and 2026 financial year, respectively. And that the PPS approves the decision and reasons for the document attached to as Annexure A. By show of hands, members, if you support the recommendation. Thank you, Mr. Kumete, Advocate Stoll, Madam Simane, Advocates Mr. Sibanda, and Madam Maseti. I also support. This then concludes item 8 and takes us directly to item 9, which is a decision and reasons for decision on the tariff application by Vopec South Africa Developments Pty Ltd for its petrol storage facility in Jameson Park, Lesedi local municipality in Gauteng province. Over to you, Madam Toa and the team.
Thank you, Chair. This again is for Vopec's facilities in Jameson Park in Lesedi. They also have a capacity-based tariff of rands per cubic meter per month. So they applied for a tariff of 413.92 rands per cubic meter per month for the 2024 financial year, 423.34 rands per cubic meter per month for the 2025 financial year, and 431.41 rands per cubic meter per month for the 2026 financial year. In assessing the application, we determined tariffs of 391.60 rands per cubic meter per month, 402.65 rands per cubic meter per month, and 410.75 rands per cubic meter per month for the 2024 to 2026 financial year. It is recommended that the PPS approves the decision and reasons for decision document attached as Annexure A. Thank you, Chair.
Thank you, members. Any questions, comments, or guidance to give to the team? I don't see any. I'll then move directly to the recommendation. It is recommended that the Petroleum Pipeline Subcommittee, PPS, approves the tariffs of 413.92 cents per cubic meter per month for the 2024 financial year, R423.34 per cubic meter per month for the 2025 financial year, and R431.41 per cubic meter per month for the 2026 financial year, which is applied for by VOPEC, and approves the decision and reasons for decision document attached here to as Annexure A. By show of hands, members, if you support the recommendation. Thank you, Mr. Kumede, Madam Maseti, Advocate Chole, Mr. Sibanda, Madam Simane. I also support. This then takes us to item 10, which is a discussion on the review of the Petroleum Pipelines Act rules of 2019 and the preliminary proposal on the amendment thereof. Over to you, Madam Choi and the team.
Thanks, Chair. This is one of the submission that Mr. Riba would have introduced. However, Mr. Lukele will assist in terms of introducing. Thank you.
Thank you, Chairperson, and good day to everyone. The purpose of the submission is to request the PPS to note the review of the rules conducted during the current financial year, and also to note the preliminary proposals on the amendment of the rules. NESA began reviewing the rules in order to identify any areas that might require amendment, since it has been more than 4 years since the gazetting of the existing rules, which were gazetted in December 2019. A summary of the identified potential amendment, Chair, is provided in Table 1 on page 10, which I will take as read. And Chair, the areas identified for amendments are currently not considered substantive enough to warrant a revision of the rules, and more work still need to be done in this regard. It will be an ongoing process. And Chair, lastly, just to apologize that the track changes version is not attached to the submission. However, all the identified potential amendments are captured in the submission and summarized in Table 1 on page 10. The recommendation is for the PPS to note the review of the rules conducted during the 2023-2024 financial year, and to also note the preliminary proposals on the amendment of the rules. Thank you, Chairperson.
Thank you, Mr. Lukele. Members, any comments, questions, guidance? I don't see any hands. Mr. Sibanda, over to you, sir.
Yeah, Chair, I think it's good to see some of the efficiencies that might come as a result of these rules. But then I think it might help maybe just to provide an example of how a typical application, for instance, might be impacted by these rules in terms of efficiency gains regarding timelines and all of that. But I think I'm in support of the recommendation. Thank you, Chair.
Thank you. Going forward, then, team, if you can just look at putting some examples, practical examples, so that members can have insight in terms of better understanding in terms of what the impact would be to stay as is with those rules. I hope that is clear. Do you want to say anything there, Mr. Clover? Mr. Lukele, sorry.
From my side, noted, Chair. I see you, Mr. Unted.
Okay, thank you, Mr.
Good afternoon, Chair. We will enhance it further, but in Table 1 on page 4, we did try to address at least it in basic, but we will enhance that to be clearly showing what the efficiency will be.
Thank you. Okay, moving to the recommendation, which is that the Petroleum Pipeline Subcommittee considers and notes the review of the rules conducted during the 2023-24 financial year, and as well as the plenary proposal on the amendment of the rules. By show of hand, members, if you support the recommendation as provided. Thank you, Mr. Sibanda, Madam Simane, Mr. Kumete, Advocate Tole, Madam Maseti. I also support. This then takes us to item 11, which is a final report on the findings of the investigation of the Petroleum Oil and Gas Corporation of South Africa, SOC Limited, PetroSA for short, the complaint against the Transnet National Ports Authority, TNPA, a division of Transnet SOC Limited, in terms of Section 31 of the Petroleum Pipelines Act 2003. Over to you, Madam Ntwa and the team.
Yes, thanks, Chair. I think this one, Mr. Untit will assist in terms of highlighting the final findings and comments from the consultation that happened from the preliminary finding. Mr. Untit, thanks.
Thank you, EM and Chair and members and stakeholders. The important point maybe first up is to show what's happened since that. That was one of the questions that the members asked at the previous time. So this is the final report after we've just informed via letter of the preliminary findings, and we did get extra comments that's incorporated in this submission. I think, and then the other thing maybe just up front, the complaint basically from PetroSA was three as elements, as they've put it: not complying, TNPA not complying with the NASA tariff, that was it, and then the other two matters was dealing with the lease agreement, which the second element of that was also speaking to the tariff. That's the context. As I said, the regulator received the comments from the TNPA as well as PetroSA, and that is summarized in the document under the headings there, page 7, for example, PetroSA review, NASA's review, then we will discuss now, and then the same for the others, and then I will summarize the findings. So in short, I think the argument, if I move to NASA's view, page 8, the overstamp page, the findings, there was a discussion on what should be shared or not, but that's dealt with there. I'm not going to do that. The key issue, members, is the fact that there's cargo dues and fees payable in terms of the National Ports Act. And then there's the maintenance element, which is directly inherent or part of the NASA tariff decision and methodology. I think that's important to note. So I think NASA's view is that, based on our legal advisory service also, that when we look at the validity or the lawfulness of any agreement entered between two parties, that NASA may pronounce in the sense that in its analysis it's not favoring the objectives of the Act, or it's not doing what the Act intended. However, in terms of declaring it null and void, and basically that can only a court of law do. So there, it's not possible then to sort of grant or give the relief that PetroSA was seeking. In terms of TNA responses, they responded to each of the preliminary findings, and that's listed from page 10 to 11. In terms of the maintenance cost, as I said, when we look at the tariff, need to look at maintenance cost, and then the other matters or the other fees and surcharges, if I may use that term, that's outside NASA's mandate, but within the Ports Act, which is a current mandate. The last aspect I want to highlight to the members is the exclusivity term that's clearly in the provisions and the clauses of the agreement between the two parties. So in terms of that, we enhanced that section compared to the previous submissions that the members may have seen, and even in the RFD included the market analysis to look at the competition aspect of the access and the way the exclusivity is granted to Petro SA as the operator. Then the conclusions we list there on page 13, basically, before I get to that, just summarize the findings, is that this is a classical case where there's concurrent mandates, the National Ports Act, and their TMPA explains it that they are bound by that act and that legislation to do certain things in a certain way versus the Petroleum Pipelines Act, which also looks at access and third-party access. So I think in terms of that,
if you can summarize, please.
I'm summarizing, thanks, Chair. Then on page 18, under the decision, basically we captured the findings in those 2 pages. So effectively, the fact that there's cargo due, port dues, and TMPA is entitled to charge that, but that forms part of the BFP fuel recovery process too. Second finding, so as such, there's not relief there. I think is what I'm trying to say that NASA can grant there. The second findings deal with the overlapping jurisdiction and concurrent jurisdiction. Finding 3 then deals specifically with the maintenance. And whether NASA or not, and if so, if there is, if I may use the English, lack of a better word, double charging or not. And then the last finding, the request was to give relief from Petro SA, basically to declare the contract null and void, which we indicate that NASA don't have the powers, but the exclusivity in that contract, and NASA is of the view that is not in line with the intent of the Petroleum Pipelines Act, and therefore TMPA as the owner of the asset licensee, or even if it appoints a operator, needs to provide it or operate it in such way that there could be third-party access. The recommendation from the PPR team captured on page 15.
Take the matter as read.
Okay.
Take the matter.
Thank you, sir.
Thank you. All right. Members, any questions, comments, guidance on this submission? I don't see any hands. I will then proceed to the. Oh, there's Madam Massetti. Madam Massetti, the floor is yours.
Thank you, Chairperson. Chairperson, sorry, there was an issue with with raising my hand. Chairperson, I am concerned about the issue of exclusivity, and I just wanted us to be very clear and categorical in respect of our views when it comes to the clauses that pertain to exclusivity. I would assume that the colleagues have checked the regulations pertaining to a third-party access, and there should be reference to the regulations where third-party access is not supposed to be provided on undue discriminatory basis. And obviously exclusivity is also something that is not accommodated there at all. It is discouraged as well as discrimination. So on this particular one, I would like to find out what exactly is NERSA required to do. The team must make specific recommendations as to how NERSA is going to deal with the exclusivity clauses that are contained therein. And I know that there will also be because we're a sector regulator here, there will also be a concern by the competition authorities. So there will be 3 authorities that are concerned about the issue of exclusivity here. So I would like to understand, how do we deal with it on our own, first of all, but secondly, on the basis of cooperation with the other authorities or within the context of regulatory advocacy? Thank you.
Thank you, Madam Massetti. May you please respond?
Thank you for the question. Yeah, valid point, Ms. Massetti. I'm just trying to find the page in terms of the recommendations on our first what we are doing. So the view from our legal colleagues was that we should clearly indicate that what your concern you raised, that this is not what the Act intended, but we do not have the powers ourselves to set it aside. But maybe that's an oversight, and we will enhance, is to the recommendation then is that the guidance we got from legal is that we can approach a court to then do the actual setting aside. The second one you already indicated, but again maybe we were not clearly stating it, was also then to approach the Competition Commission, as you correctly indicated, because there's also a similar situation, I think, on the gas side where we expect or there was a ruling in terms of that. So I think we will enhance the submission, but maybe legal can help me. But the 2 recommendations to the committee is that we do indicate that is a problem, the exclusivity. Secondly, we can approach a court which have the powers to set aside such a, and then secondly, NASA can approach or engage with the Competition Commission, because we did add a whole section and an analysis in the RFD about the competition and the potential anti-competitive behavior. So I'm not sure if I've answered your question, but yeah, it's lacking then in the document in front of you. Apologies for that.
I think the issue being put forth here is that let us just be categorical around it, about this, and then is that we require the licensee to be in compliance, because it's not complying with our regulations or what is stipulated in the regulatory framework. We just require that from them, and then the people with legal minds can then come in and win. But for me, it's a straightforward matter to say, be categorical about this, state exactly what is required to comply. Then we take the necessary steps if there is still non-compliance. I don't know whether, Madam Massetti, I'm putting forth your sentiments correctly.
Yes, Chairperson, you do. I wouldn't like this kind of interpretation that let's run to the courts. We are legal people operating within the regulatory space. So if the parties are doing something that is inconsistent with the provisions of the law, we tell them straight that what they are doing is inconsistent, because first of all, we don't have provisions that talk to reserve capacity when it comes to access. We don't have that. So what we have is the what you call the unutilized capacity. So if capacity is unutilized, then that capacity must be released to the market. That's the kind of a regime that we have. So once now they do exclusivity, it means that will also mean that they reserve certain capacity so that other people don't get it. So why is it wrong to then do an interpretation that states clearly in simple terms what our mandate is and indicates clearly that when it comes to exclusivity, it is inconsistent with the regime that we have in our legislation, and therefore they must remove it. We have done it in gas, and also recently, 2 years ago, and the legislation is similar. So we must be straightforward and not talk to the courts. We'll go to the courts if we are challenged with what we have said. Thank you, Chair.
Thank you very much. Madam Chair, your hand was up. I think you addressed.
Yes, Chair, I think we covered me. I wanted to say that also when we're communicating the decision, we'll then address that in the letter to indicate clauses that are not complying with our legislation. Thank you, Chair.
Thank you. With that, we're moving to then the recommendation, which is on 14.1, page 15 of 50, which is the recommendation that the Petroleum Pipeline Subcommittee considers and approves the report on the NERSA's final findings of the investigation into the complaint that was lodged by Petroleum against TNPA in terms of Section 31 of the Petroleum Pipelines Act, a report which is shared and attached herein as Annexure 1, outlining the final findings in the decision and reasons for decision document, subject to the enhancement as articulated during the meeting. By show of hands, members, if you support. Thank you, Madam Maseti, Mr. Sibanda, Advocate Tole, Mr. Kumete, Madam Simane. I don't see Madam Simane. Madam Simane, are you still there? I guess I'll just have to proceed then with the majority of the members. I also support from my end. This then concludes item 11 and taking us straight to item 12, which is a Bidvest 10 Terminals Richards Bay Prudence Assessment Report. Over to you.
Chair, apologies. I don't know what's happening. I do have a little bit of connectivity issues.
Okay, noted.
Okay.
Yeah, all right then. Let's then, but you support the recommendation?
Yes, I do.
Thank you. Okay, so it's supported by all the members. This then takes us to item 12, BTT Richards Bay Prudence Assessment. Over to you.
Chair, Mr. Flojana will assist in terms of introducing this one. Thank you.
Thank you, Chair, and thank you, members and colleagues. I'm just going to be brief, and I'll take the report as read with its annexure 1, which is the detailed report and the in-depth analysis of the prudency assessment report. But I just want to maybe draw the members and colleagues to, I think, just 2.1 of the report. What we are here for, which is to request PPS to approve the prudency assessment that was conducted for Bidvest tank terminals, but also just to maybe point the members to 5.1 on page 4 of 8, which is the steps that were done or the approach that we took to conduct this assessment as well. And also maybe in closing to highlight that I think the motivation, which is 5.2, to conduct this prudency assessment is, I think, amongst others, that DMRE uses this facility as well when it's setting its LPG prices. But also for us as PPR was to ensure and check that all the capital costs that were used for the tariff application are fair and are in line with what PTT is charging its customers. Thank you, Chair. I'll take the report as read with its annexure, which is the in-depth report on prudence assessment conducted for PTT. Thank you.
Thank you, Mr. Mflochane. Members, any comments, questions, or guidance? Seeing no hands, I will then move to paragraph 14, which is the recommendation. Oh, I now know that Mr. Sibanda has got his hand up. Mr. Sibanda, the platform is yours, sir.
Chair, just a minor one. It's not clear. So I'm trying to get to to the page. I think on page 18 of 22, where they're explaining the variation. It's not clear what led to the change in scope, or rather what was that change in scope relating to Mott MacDonald. I think it might have assisted just to indicate how the scope of the project changed and what that change was. And then secondly, I see that we have calculated the percentage variation as out of the total cost. That is, sorry, I'm on page 16. So I think we've taken the total cost of the initial amount plus the variation, and then we calculated the percentage variation out of that total amount, instead of calculating the variation from the initial amount. I'm not sure if that's correct. The 7.74%, calculating it from the final or total amount instead of calculating it from the original amount. Maybe if can be clarified there, why are we calculating it from the amount that already includes the variation? Because if you do it from the original amount, then the variation is around 8 point something. Maybe it can be clarified on that. Thank you, Chair.
Thank you, Mr. Mtochana. If you may please respond.
Thank you, Chair. Maybe just to deal with the issue of variation, I think maybe Mr. Sibanda might not have seen it. The variation was calculated using the total amount, subtracting the initial amount to get to 77 or so million. And that 77 million, it's basically the 7.74, the total or extra or variation amount. So I think that's how we calculated it. I think just to explain.
Yeah, maybe just to clarify, I'm saying,
yeah,
why did you calculate the variation percentage taking the 77 divide by 920? Sorry, divide by 998 instead of dividing it by 920? That's my question.
Okay. All right. No, I see. Yeah. In many cases, how we calculate the variations, that's how we do that. But one person may just take the finish or total cost and then minus the initial cost. But for our analysis, we thought it's best that we reflect it as such and then just divide it with that amount to get to 7.74.
I think we better look at it, Mr. Chana, because there could be a justifiable reason, because you've got a variation, and then if you take that variation and you look at what the original amount was, it could make good sense, and actually it's more informative as to the level of variation you had from what you initially set out to have as an outlay vis-a-vis what you ended up having at the end of the day. So being a percentage of the original amount, I think it wouldn't do any harm actually to even have a percentage that indicates both if need be.
And it is noted, Chair. I think we'll take that enhancement, because I see when we do our method versus what Mr. Sibanda is suggesting, it's basically roughly 1% difference, but we will look into that and enhance it accordingly.
Thank you. On the other one? Mr. Sibanda, are you covered?
I'm covered, Chair, on that aspect. All that I was saying is perhaps with respect to the change in scope, it would have assisted to maybe just give an indication of what that scope change was. But I'm covered. Thanks.
Okay. That's fine then. This then takes us to the recommendation, which is on page 8 of the submission, which is paragraph 14, where the Petroleum Pipeline Subcommittee is requested to approve the final report on the prudence assessment conducted on the Bidvest Tank Terminal petroleum storage facility in Richards Bay, and 2, to approve the prudence assessment and findings as captured in the Annexure 1 PTT Prudence Assessment Final Report, financial year 2023-2024, with the enhancement that has been highlighted during the meeting. By show of hands, members, if you support this recommendation. Thank you, Madam Simane, Mr. Kumete, Madam Maseti, Mr. Sibanda, Advocate Stolle, I also support. This then takes us to item 13. I'm looking at item 13 and 14, members, and I think that being a governance matter, that we take it to the closed part of the meeting. If you support me in that as governance matters. By show of hands, if you support that, members. Thank you, Mr. Kumete, Madam Maseti, Madam Simane, Advocate Stolle, Mrs. Banda. I also support. Then let's move it to the governance part. Mrs. Banda, I think you wanted to say something.
No, Chair, it's fine. I wasn't convinced that the first item is actually governance, but I will abide by the majority, Chair. Thanks.
Thank you. Okay, let's move then to item 15, which is infrastructure utilization and third-party access to petroleum storage facilities. The report. Over to Dr. Polo.
No, thank you, Chair. Good afternoon, members, colleagues, and management. Madam Mabija would lead us in terms of presenting the summary of the report. Thanks.
Take the matter as read and just highlight on the key issues. We've got 2 minutes.
Thank you, Chairperson, and good morning, colleagues. The purpose of the submission is the purpose of the submission is for the PPS to note the analysis of petroleum infrastructure utilization to determine uncommitted capacity and third-party access at petroleum storage facilities. A few things to note in the submission is that it covers data received from licensees as at 24 January 2024. Overall, the analysis detailed in paragraphs 14 to 46 of the submission shows that a majority of petroleum storage facilities are underutilized. This indicates that there is opportunity to increase the number of third-party participants, in particular the non-integrated oil companies, which are third parties in this case. And as seen in Table A1, the level of third-party access is 9.5% for emerging third-party participants or non-integrated oil companies. This is a slight increase in the level of third-party access noted in the previous PPS of September 2023, that was 10.7%. This is due to the increase in the number of facilities with usable data for analysis that has increased from 110 to 137. Although there are 20 facilities that were found to be accommodating third parties, 12 of those are hosting non-integrated oil companies. It is also important that challenges identified through monitoring which are detailed in paragraphs 57 to 62 of the submission in Annexure 1 are also noted. Therefore, it is recommended on page 11 of 50, Chairperson, that the PPS notes the submission for the 2023-24 financial year, reporting on the analysis of infrastructure to determine uncommitted capacity and third-party access, the level of third-party access to petroleum storage facilities, the list of petroleum storage facilities identified to have uncommitted capacity in Annex B here too. Licensees accommodating third parties identified access challenges through the monitoring of requests for access and efforts by NERSA to assist third parties, challenges impacting on the work of NERSA pertaining to third parties, and lastly, attempts made to engage with SARS on third party access and assisting licensees. Thank you, Chairperson.
Thank you, Madam Mabija. Members, any questions, comments, guidance? I don't see any. To the recommendation, which is for the PPS to note the second submission for the 2023-24 financial year reporting on the analysis of infrastructure utilization to determine uncommitted capacity and third-party access at petroleum storage facilities, the level of third-party access to petroleum storage facilities, the list of petroleum storage facilities identified to have uncommitted capacity, including paraffin tanks that were put on hold from publication in August 2023. Licensees accommodating third parties and VOPEC being the best performer in this regard. Identification of access challenges through the monitoring of requests for third-party access to these facilities. I think I just had a challenge. Sorry there, members. I just had a screen blank out. Yeah, the next one is the challenges impacting on the work of NERSA pertaining to third-party access and limitations to making third parties accept a space if there is a mismatch to what was requested versus what was offered. And lastly, attempts made to engage with SARS, where the onus is with the licensees to comply with both NERSA and SARS requirements. When necessary, consent letters would be sought from the licensees to obtain certain information from SARS. That is the recommendation. By show of hands, members, if you support the recommendation. Thank you, Mr. Kumet, Madam Maseti, Advocate Tole, Mr. Sibanda, Madam Simane. I also support. This then concludes item 15 and takes us to item 16, the biannual report on the monitoring and enforcement of compliance with operation license conditions.
Chair? Yes, no, thanks, Chair. This is one of Mr. Mapoli's submissions, but Ms. Mabija will assist in terms of introducing it. Thanks.
Thank you.
Thank you again, EM Chairperson. The purpose of the submission is to request the PPS to note the second biannual request for the financial year 2023-24 on the level of compliance by licensees with the conditions of their operation licenses for the period as of 1 July 2023 to 31 January 2024, attached here to as Annex 1. The report attached here to as Annex 1 provides details on compliance from pages 9 to 25 with regards to average actualization, average actual storage facility utilization, allocation mechanisms, and third-party access, and HDSA participation. In terms of the monthly storage utilization, Chairperson, the level of compliance sits at 90% for above bulk licensees. And for allocation mechanisms, it is currently at 83% for all the petroleum. 83% of all the petroleum storage licensees have lodged their allocation mechanisms with the energy regulator. Of the 11 that are outstanding, 10 are those that are below bulk, and 1 is an above bulk licensee, which is pending a revocation. The level of compliance in terms of HDSA or BE compliance is 100% for the reporting period, with the exception of 3 licensees that have no black ownership at all. Overall, the compliance levels with license conditions and the regulations in this reporting period have improved following efforts by the team to remind, follow up, as well as conduct other engagements such as site visits in line with the PPR compliance monitoring and enforcement framework. of 2019. Therefore, it is recommended, Chairperson, on page 4 of 61, that the PPS notes the second biannual report attached here to as Annexure 1 on the level of compliance by licensees with the conditions of the operation licenses issued for the 2023-24 financial year as at 31 January 2024. Thank you.
Thank you, Madam Mabije. Any questions, comments, or any guidance from members? By show of hands, please. I don't see any hands, so I will then proceed to the recommendation, which is for the PPS to note the second biannual report attached to as Annexure 1 on the level of compliance by licenses with the conditions of their operation license issued for the financial year 2023-24 as at 31st January 2024. By show of hands, members, if you support the recommendation. Thank you, Madam Maseti, Mr. Kumete, Mr. Sibanda, Advocate Tole, Madam Simane. I also support the recommendation, which then concludes the matter and takes us to item 17, which is a biannual report on the monitoring and enforcement of compliance with construction license conditions. I take it that Mr. Lukele will assist us. You've got the 2 minutes, taking the matter as read.
Thank you, Chair. This item is similar to the previous one, but now we are looking at construction licenses. And currently there are about 13 projects that are regarded to be active, and the changes to these active projects since the last biannual report noted by the PPS in September are detailed in paragraph 12 of the report. And effectively, Chair, currently we have about 2 projects that the actual construction has commenced during the reporting period, and both projects are progressing as planned. And Chair, of the 11 projects that are in reconstruction, 10 of those are delayed for various reasons, and the majority of which are beyond the affected licensees' controls, but the details are in the report. With respect to the application, Chair, we NESA received 2 new applications during the reporting period. The one was by BTT, where they are proposing to construct two new tanks, which, if approved, will increase the storage capacity in Richards Bay for diesel by 30 million liters. And another application from VOPEC for Lesedi, and it's also for diesel, and if approved, this would increase the VOPEC storage capacity in Jensen Park by 40 million liters. And these applications are going through the process. Lastly, Chair, talking to the non-compliance, which is covered in section 5 of the report, subsequent to the sign-off of the report, we did receive progress reports from Avidia, and therefore that non-compliance highlighted there was remedied. And Chair, the non-compliance that still remain a challenge is with respect to licensees failing to meet the construction timelines, and this is particularly to commence with construction. And in the last report, one of the licensees that was non-compliant was PTT for Isando project, but this has subsequently been discontinued and revoked. And also the other one was with respect to Transnet, but then the amendment that was requested was granted. And with respect to the non-compliance licensees currently, NESA has shared the necessary forms with the licensees consent, and both of the licensees are on their final reminders, and the letters are currently circulating for sign-off. And lastly, the last point, Chair, I think it will also important to note that the licensees have kept NERSA informed of the challenges experienced through the progress report, which are summarized in table 2B on page 10 of the report. Thank you, Chair, and the recommendations for the PPS to note the report. Thank you.
Thank you, Mr. Lukele. Members, if you have any questions, comments, or guidance to give to the team, please raise your hand. Thank you, Madam Maseti. The floor is yours, ma'am.
Thank you, Chairperson. Chairperson, I think we also need to just pay attention to those projects that are delayed. Remember, we license for a reason when we license infrastructure. So, so that may also have an impact in future infrastructure, future investments in infrastructure, if there are certain bottlenecks or unreasonable delays that happen in the process. So that should also be looked into in terms of how it will impact on the infrastructure. But the other critical issue to consider is the impact of such of the delay in commissioning the licensed infrastructure. Or completing the licensed infrastructure, because remember, the cost also goes up. So there might well be some of the things will become expensive than they are. And also in terms of access of the product or the utilization of that infrastructure by the industry players will also be affected. So in terms of access, that will be an issue. In terms of cost, it will be an issue, but also in terms of investment. But nothing, the team has not touched on those things to look into the relevant geographic market or where the infrastructure was supposed to be utilized, and those that needed to utilize the infrastructure, how urgent, how important it is. So these are kind of things that the team must look into going forward. Thank you.
Thank you. I hope the team have noted that. Any response from your side?
Chair, we've duly noted, we'll add it. Maybe just, I think the biggest problem is in Durban, Ms. Masetti, with those two projects. The one is part of litigation between the parties and the landlord, and the other one is busy with arbitration with the landlord. But yeah, we make this as an enhancement when the next report is done. Let me specifically capture your comment on the impact and on in the next report, ma'am.
Yeah, thanks. I note your thumbs up, Madam Masetti, and I must say that on some of these, as FTRM Petroleum pipelines, I had to step in, and because there are litigation issues delaying the resolution of these matters. It's something that I think in the amendment of the law we also need to try to capture, so that we can be able to deal expeditiously with such challenges, as well as the fact that when we are looking at the forecasting of demand, looking at the market dynamics, one needs to come to some landing in terms of whether to take that particular project as being in the baseline or not, which is a challenge that we hope with amendments being mooted from our side, it would be to a great extent attended to. But it's something that the team needs to constantly work on, try to improve, find ways of I would say negotiating their way through, using, of course, the empowering provisions of the Act. But thanks a lot for that. We'll then move to the recommendation, which is on page 5 of 33. It is recommended that the PPS notes the biannual report on the monitoring and enforcement of compliance with construction license conditions attached here to as Annex 1 on the progress made on the projects licensed by NERSA and the level of compliance by the licensees. Members, by show of hands, if you support this recommendation. Thank you, Madam Masetti, Mr. Sibanda, Mr. Kumete, Advocate Tole, Madam Simane. I also support the recommendation. This then concludes item 18 and takes us directly to item 19, which is
Total 18, Chair.
Sorry, 17, and it takes us to 18, which is an annual report on licenses issued and geographical spread of facilities. Over to you, Madam Toa and the team.
Chair, they seem to have an error on convene. If the actual item that we're dealing with now is the annual report on investigation done into suspected unlicensed activities for the 2023 financial year, 2023-24 financial year. And then number 20 will deal with the geographic spread of facilities. May we allow Mr. Lukele to talk to the suspected unlicensed facilities? Thank you, Chair. Mr. Lukele?
Oh, thank you. Thank you, Chair. This is an annual report on the investigations into suspected unlicensed activities conducted in this financial year. The report, it's here for noting by the PPS in line with the APP. It used to be submitted to the REC. However, the delegation matrix was changed. The delegation for it was changed to PPS in October with the revised the delegation matrix. And Chair,
just hold on there. Just want to check now with the members if they do have that report, because it moves from mine. It moves from compliance with construction license, then it goes to 18, which is the annual report on licenses issued on and geographic spread of facilities. Then 19 is the Petroleum Pipelines Regulation Project status report. And then 20 is the annual report on licenses issued and geographical spread of licenses, which is erroneously repeated. You've got the geographical spread twice.
Chair?
Yes.
Chairperson, is just an incorrect title. The report itself is on unlicensed activities, but the title is what is incorrect, Chair. Thanks.
Okay, so you proceed with this one as per the title that is in the annexure, not the agenda item title. All right. So then proceed then with this one.
Thank you, Chair. And maybe the only thing I would just like to indicate, following the update of delegation matrix, which the report also contains, there was a provision made for the FTRM to confirm exclusion of non-bulk storage facilities. The report also include those cases or those matters for noting. In summary, Chair, in this financial year, and as the time of preparing the report, which was 12 February 2024, NESA excluded a total of 13 storage facilities from licensing, with a summary provided on table 1 on page 6 of the report. And in terms of the range, the largest facility that was excluded from licensing has a design capacity of 770 cubic meters, which is less than the current threshold of 1,500 cubic meters. And the average share of capacity of storage facility that might not require licensing, it's 110 cubic meters. And all the exclusions were based on the bulk storage determination. And the PPS in this financial year has considered 2 reports on the bulk storage determination, and NESA is preparing another report on the bulk storage determination, which is to be submitted to PPS before the end of the first quarter of the next financial year. Chairperson, the report also includes details of site inspections conducted during the financial year, and these are discussed from paragraph 20 of the report. And lastly, Chair, the list of all activities data might not require licensing since NASA inception is attached as an Nature 1 to the report, and it's updated as and when new cases are dealt with. Chairperson, in closing, there are two recommendations. The first recommendations for the PPS to note the report, and the second recommendations for the PPS to note the FTRM's confirmations of the non-bulk storage facilities that do not require licensing as provided for by the bulk storage determination. Thank you, Chair.
Thank you. Mr. Lukele, members, any comments, questions, or any guidance you want to give to the team? I don't see. Oh, yes, Mr. Sibanda. Mr. Sibanda, over to you, sir.
Chairperson, you will guide me here. I'm not sure whether what I want to raise is a governance issue or not. But when I looked at in this table 2, the pending cases, that's on page 13, running to page 14. Of those unlicensed facilities. It's a bit concerning, and I don't know how we do these inspections, but so does it mean that we go into these facilities and unaccompanied, and I don't know the security implications and all of that, but also if you look at the responses, it's like these people are non-responsive, and it's just concerning to me, Chair. And like I said, I don't have any experience in terms of these inspections, but when I looked at what's happening here, and I'm not insinuating anything, Chair, but it's just a concern from a security perspective, how we or maybe let me ask the question whether there are any security concerns. Thanks, Chair.
Thank you. I will leave it at that level of security concern. If there are any other outstanding matters, we'll deal with them as part of the governance section of the meeting. If you may then respond, if there are any security concerns.
Chair, it's Martin. I just want to check, did Mr. Sibanda mean with regards to us as staff or security in the context of something happening at such an activity where we can't get access?
Just both, if you can just help, just
okay.
To the point, please.
So in terms of the security of staff, I think we also, there's corridor workshop that we've had, and we also make sure that we don't endanger the staff when we do it. In some cases, they just flatly refuse us access, and then we will deal with that in a different matter. In that regards, Mr. Sibanda, we have joined the compliance forum with the Department of Mineral and Energies, and they are looking at establishing peace officers. We've also had an engagement with SARS Unlicensed Activities Inspectorate, which has got much more powers in terms of their act, and they actually want to meet with us next week to look at cooperation. And then we've also now entered with the gas department as part of a PGS. I'm not sure, maybe the PGS members will remember there's a safety and regulation project. With that, we are busy meeting with SALGA and we also with the Department of Labor, and we're sharing this information then with them to assist us, because they do have much more powers than we currently have in the Act. I hope I've answered your question, sir.
Thanks, Mr. Unti. I think it will help then in subsequent reports just to reflect on the issue of safety and security overall, not also forgetting to also check on the issues of any whether it's criminality or that which is part of law enforcement. Just to be able to look at that and include it in your reporting. I think it will then assist in dealing with this matter. I know that there are various platforms where these matters are being handled, but just in summary, to look at it in as far as it affects all the stakeholders that are involved, noting also the state of safety and security in our country. Mrs. Banda, are you covered?
I am, Chair. Thanks.
Thank you very much. This then takes us to the recommendation, which is for the PPS to note the annual report on investigation done into suspected unlicensed activities in the 2023-24 financial year, attached here to as Annexure A, and notes that the FTRM confirmed that the following storage facilities do not require licensing in terms of the Act as provided for by the bulk storage determination, which is Black and White Investment Pty Ltd's proposed storage facility in Delmas, Mpumalanga Province, at 25 cubic meters, and then Exit Energy Pty Ltd's existing storage facilities in Olifants Spray, Gauteng Province, 2 sites each 40 cubic meters capacity. Then Mangaliso Energy Pty Ltd's existing storage facility in Brackenfell, Western Cape Province, at 69 cubic meter capacity. Matrop Holdings Pty Ltd's proposed storage facility in Ladysmith, KwaZulu-Natal Province, which is at 75 cubic meter capacity. And lastly, Ubuntu Gas Petroleum Pty Ltd's proposed storage facility in Benoni, Gauteng Province, at 51 cubic meter storage facility. This then concludes the recommendation. By show of hands, members, if you support the recommendation. Thank you, Madam Maseti, Mr. Kumete, Advocate Tole, Mr. Sbanda, Madam Simane. I also support the recommendation with that enhancement in future reports. We then take, I think item 19 will be part of what goes into the governance part of the meeting. We'll then go on to item 20, annual report on licenses issued and geographical spread of facilities. Item 20, if you can just assist there.
Thank you, Chair. Ms. Stimbile Dlamini will assist. Thank you.
Thank you, ma'am. Thank you, Chairperson. Afternoon, members. Apologies for the diagonal line that appears throughout the submission. The objective of this report is to provide the analysis of applications considered during the current financial year, new entrants into the industry, as well as the geographic spread of petroleum pipeline infrastructure. I'd like to highlight the following in part 1 of the report. Table 2 on page 8 and 9 lists the applications considered and still in progress. Table 3 on page 10 and the information below the table relates to a new entrant. It should be noted that even in the previous financial year, only one application from a new entrant was considered and approved. Table 4 on page 12 to 14 details meetings that the division had with potential new entrants, one of which has submitted a license application to operate a storage facility. The application is still in progress. Part 2 of the report focuses on the geographic spread of petroleum pipeline infrastructure in the different provinces. It is therefore recommended that the PPS notes the report. Thank you.
Thank you very much, Madam Dlamini. Members, any questions, comments, or guidance you wish to provide to the team on this submission? I don't see any hands. I will then proceed to the recommendation, which is for the PPS to note the report on the geographic spread of licenses issued for petroleum pipelines infrastructure and new entrants into the petroleum pipelines industry during the period 1 April 2023 to 31st January 2024, which is attached here too. Thanks, Madam Maseti. I see by show of hands, Mr. Kumete, Advocate Tole, Madam Simane, Mr. Sibanda, I also support. This then concludes item 20. We'd like to just go back to item 5, which deals with the guidelines on volume risk sharing mechanism between Petroleum pipelines, storage and loading operators and third parties. Take the matter as read, highlight the key issues. I think you just expand when it comes to the questions and answer slot. Over to you. Mr. Kaba.
Thank you very much. I hope I'm audible. Chair, I will take the purposes read. Just a little bit of background, maybe. In the 2022-23 tariff determination for the Transnet pipeline, MESA only implemented a portion of the revenue clawback while investigating a suitable volume risk sharing mechanism, which would take into account, after taking into account Section 10, 1D of the National Energy Regulator Act of 2004. In the decision, NASA found it reasonable only to implement only 50% of the revenue clawback in the interim. And the final decision on the matter would then be followed by or informed by research, facts and evidence that would be provided after taking into account what's inputs from stakeholders, including Transnet itself. Subsequently, after conducting its research, on the 17th of March 2023, the Energy Regulator published a discussion document on its website depicting the interim volume risk sharing mechanisms that were recommended at the time. Only two stakeholders, Sasol Oil, as well as Transnet, submitted written comments to that discussion document. And on top of that, we also conducted stakeholder engagements, one-on-one or face-to-face, with the BPSA and Total Energies as well. And the stakeholders also expressed their views on the volume risk sharing mechanisms that were suggested at the time, as well as also how the volume risk sharing concept can also be expanded on. Furthermore, on the 13th of December 2023, a PPR workshop was also held with further inputs to be made into the final document that will go into in terms of the workshop. It was suggested that an expansion of the legal framework was needed, as well as in terms of the deferment of the allowable revenue at certain criteria that pertain to the volume profile, as well as a bunch of other considerations. The PPR also thought it best to also look into disallowing a portion of the revenue clawback as a form of volume risk sharing, as well as other recommendations or a combination of the two. After taking those inputs into consideration, the energy regulator, amongst other considerations as well, we also decided to have a number of recommendations, or take a few recommendations that we take into that we take that we would suggest as potential volume risk sharing mechanisms that can be utilized, which is the deferment, the recognition of a regulatory asset liability, a partial disallowance of allowable revenue, as well as a simultaneous utilization of the two, which would be the deferral and the disallowance in itself, as explained in the document. Although NASA had already asked the public to comment on the volume risk sharing mechanisms, some new information came into light, which is what is contained in this document, and we thought it best to take these new recommendations onto to public for public comment, so that the affected stakeholders could also have their say into these new recommendations and the rationale. So it was thought best to compile a guideline that would then be put out for public consultation as well. Hence, it is therefore recommended that the PPS notes the draft guidelines that we would then put out and approve the publication of those guidelines. Thank you very much, Chair.
Thank you, Mr. Gaba. Members, from your side, by show of hands, if you've got any questions, comments, or guidance to give to the team. Mr. Subanda, sir, platform is yours.
Thank you, Chair, and thank you to Mr. Gaba. Chairperson, we have characterized all these mechanisms as volume risk sharing mechanisms, and I'm not certain that they are all risk-sharing mechanisms in the strict sense of the word. So for instance, if you look at, well, starting from paragraph 5.1 on page 5, that list of mechanisms there, you've got fiscal stabilization, which is more of a government assistance program. You've got other government incentives and policy and regulatory development. Under private risk sharing, you've got insurance and the like. But if you go into the detail from pages 19 to 23 of what these mechanisms are, the majority of them are actually not risk sharing per se, but perhaps they sound more like a risk mitigation mechanism than a risk sharing mechanism. Because if you look at how we've defined a risk sharing, we've even said it in the submission that is sharing of risk between the licensee and its customers. But some of these really are just risk mitigation measures. And maybe the team may want to comment on that. So for instance, if you look at the partial disallowance, and we simply kicking the can down the road or down the line, because at the end of the day, somebody else is still going to pick up the tab. It may not be, the current users; it may be future users. So how is that risk sharing? Also, I think it's also important. For instance, I'm looking at page 7 now. When we talk of disallowing allowable revenue, that we don't frame it in such a manner that we are disallowing revenues in order to keep tariffs low, because I don't think that's correct. You can only disallow revenues because there is lack of justification, perhaps for the investment program or the capital program that the licensee intends to undertake. So there could be, lack of justification in terms of whether that investment is certain, in terms of timing, in terms of cost. But I don't think we can say that we'll disallow revenues, whether partially or however, in order to keep tariffs low. I don't think that would be correct as a regulator. It doesn't sound right to me. But certainly, where there's lack of justification, yes, indeed, you can disallow certain aspects of the allowable revenue. So, yeah, and then on page. On page 46, where we talk of disallowing a portion of the revenue clawback as a form of volume risk sharing, it will be important to probably have, certain criteria that needs to be known by licensees upfront, and not something that we'll think about when we have an application before us. I think there needs to be clear guideline or criteria that licensees need to be aware of upfront. That's all from my side, Chair. Thanks.
Thank you very much, Mr. Sibanda. Mr. Kawe, the team, may you please respond?
Thank you very much, Chair. Initially, Mr. Sibanda, we had put out the original set of volume risk mechanisms that we had come up with in terms of our research as the ones that are put up or are listed, and you have referred to them as more of risk mitigation mechanisms rather than risk sharing mechanisms. And this was prevalent throughout the research that we were doing. There was a lack of appropriate mechanisms or examples of these mechanisms that were more used in the regulatory environment, and these ones that we had spelled out and put up for public consultation were the ones that we thought closest or would resonate our intention in terms of this mechanism. However, because of the comments from the stakeholders initially, and also bearing in mind some of the policy constraints that we have as well, we had different recommendations to these. That recommendation, we had to look at what would be more, what would resemble some of these characteristics, or some of the characteristics that are contained within the risk preparedness, public risk sharing mechanisms, and these private risk sharing mechanisms that we have listed to come up to what we deem would suit our regulatory environment, obviously within our mandate legislatively. And that took us to one recommendation, which was particularly using the creation of a regulatory asset to be considered as one of or to be considered a risk-sharing mechanism that we could utilize. However, with certain stipulations in the form of volume rules, then that would qualify some of the revenue that would be that would be allowable for lack of a better word, allowable for the licensees themselves. And in a nutshell, these volume rules would then be used as a qualification criteria for some of these funds. Just to hurry it up, so reading your message on the screen, that we tried to encompass those rules, these volume rules, as a qualification criteria to qualify for any revenue under clawback as well. Then it would inform whether you qualify for a for that clawback, and then how we would treat it then in the calculation would then be in the form of a regulatory asset. However,
sorry, Mr. Kap, that's to come in before Mr. Sibanda becomes unavailable. Just quickly, Mr. Sibanda, will it help if in these options there is a mention, maybe something like a caveat that says that we do recognize that we're looking at risk sharing, but some of these options may not neatly fall into that category, but are more of risk mitigation than actually risk sharing. Just to put that as a caveat, and then so that there is more discussion and engagement on the document. Was the publication in terms of draft guidelines is actually to seek exactly that. Will that cover you?
Yes, Chair. Yes, Chair.
Okay.
Thanks.
Thank you very much. Yeah, I think if that is covered, then quickly to go to the recommendation then, that the PPS notes and approve the publication of the draft guidelines on volume risk sharing mechanism between Petroleum pipelines, storage and loading operators and third parties, and that the enhancement as put forth be included in that publication. By show of hands, members, if you support that. Thank you, Mr. Kumete, Mr. Sibanda, Madam Maseti, Madam Simane, Advocate Stole, and I also support. Thank you very much. This then brings us to the close of the open meeting. But before we close on that, if you may just help me by going to item 21, which is the noting of the approved round robin on the decision and reasons for decision document on the Transnet SOC Limited tariff application for its Petroleum pipeline system for the 2024-25 tariff year. Just by show of hands to note, if you're happy to note. Thank you, Mr. Kumete, Mr. Sibanda, Madam Maseti, Advocate Stole, Madam Simane. I also note. This then concludes all the matters that are supposed to be deliberated in the open meeting. I would like to thank the members of the public that have been closely following us on the various live streaming platforms that we're using as NERSA. Thank you very much for taking interest on our work. And this on its own also helps to ensure that we are at the cutting edge of efficiency.